Thank you. Good morning, all. This hearing is in the matter of CFI 060-2023 and is being held by way of video conference before Justice Rene Lemiere, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Reed Smith. Lead counsel is Ms. Antonia Britt. The defendant is represented by Clyde & Co. Lead counsel is Mr. Stephen Doherty. Thank you, Your Honor.
All right. Well, thank you. Ms. Burt, I have received or have access to the draft case management order proposed by the claimant and by the defendant, and the notes in the nature of skeleton arguments which you have each provided. Now, where would you like to start, Ms. Burt?
Thank you, Your Honor. Having reviewed the defendant's note, it appears we have 8 issues that may be worth discussing today. I have the following issues. I've listed them in chronological order with respect to the proceeding. First is the defendant's document production, then the date of filing witness statements, then the period for the defendant's experts to serve their first reports, the forensic IT expert access to data, and then trial bundles, skeleton arguments, duration for trial, and very finally, there was also a reference to the issue of privacy in yesterday's note. So these are the 8 issues that I was planning to address, Your Honor, on this morning in this order, unless you have any other preferences.
No. I think we
Thank
might.
you. Thank you. Please feel free to push me along if I am repeating what you're already aware of from the party's notes, and I'm going to try not to do that, but there are a few points that may be worth raising. First of all, and before we get to the first issue, the reason why we are arguing about the timetable with the defendant to such an extent is the context of where we find ourselves in. The claimant was successful obtaining the injunction last year, and until the committal decision operated on the basis that it was protected by the injunction with respect to the continuing use of confidential information by the former employees. Having lost the committal application, the claimant has grown extremely concerned that the defendant's consideration the injunction had no teeth is now strengthened, and that it will double and triple down on its conduct. At the same time, the defendant was also successful with its attempt to delay disclosure. On current dates, disclosure will be taking place, if it takes place, around 5 months or so later than some of the original deadlines in the CMC order, and I can go to those in a moment. Without disclosure, the claimant cannot prepare or cannot finalize its quantum expert reports. We have said this to the defendant. We have written letters about this months ago. There is, of course, an imbalance in a case such as this. Again, this is all a part of the record in terms of the advantages that the defendant has with respect to documents. We have written again to the defendant that part of the claimant's claim cannot be quantified until we have disclosure. And for this reason, before the committal decision was received, we wrote to the defendant saying, in light of the disclosure delays and the upcoming deadline for expert evidence, it is no longer possible to file this expert report on the date foreseen. And we had considered also that it was not possible to compress the remaining timetable within the existing trial dates, taking into account the delay to disclosure and the impact that had. So the parties agreed to vacate the trial dates, and the next possible dates were in February, more than 4.5 months later than the original dates. And then after that, the claimant received the committal decision, finding itself now exposed with respect to the risks it considered the injunction was intended to protect until trial, and having lost the opportunity to determine the dispute in short order. Therefore, as a general matter, the claimant respectfully requests the court to impose a procedural timetable, which at the very least does not at all jeopardize the postponed trial date. That's the background to the discussions with respect to the procedural order. For this reason, we have included float in the timetable to make sure to account for any further delays that may occur, to avoid another delay to the trial dates. I should say that the parties are not very far apart at all with respect to the timetable. The differences are very minor. However, our hesitation to agree to the extended periods that the defendant has proposed here and there, and we'll go through those in a minute, it needs to be seen in this context where we are concerned that if the substantive dates, and by that I'm referring to the final date being the reply expert reports by the defendant, we are concerned that those dates should not be pushed into the new year, because if they do, then that leaves no float for any future delay, and any future delay then ends up risking and jeopardizing the new trial dates, and that is to us, in the current circumstances, unacceptable. So that's the background to the discussions with the defendant regarding the timetable. And now to the specific issues, the first being document disclosure. So Your Honor, 23rd of May document production order required the defendant to produce documents by the 21st of June. The defendant, without seeking an extension, now estimates it will comply with the order by 12th of July. Again, the state needs to be seen in the context of the original CMC order, and I thought it may be useful to put that up, Your Honor. That's at bundle page 109. I will refer to the order on a couple of occasions, so it may be useful to have that open.
Yes, I have it.
Thank you. I am now referring to item 5. At item 5, it was ordered that where there are no objections to a particular request contained in an RTP, the responding party shall produce the requesting party documents which are responsive to that request on 27th of February. So that is what the original CMC order foresaw in terms of the time period for production of documents to which no objection was made. We do, or as Your Honor will recall from the disclosure application, there were significant parts of our requests to which the defendant had in fact agreed, but did not provide those documents either by the date or in fact to date, majority of the documents to date, because it requested us to waive our related requests or other parts of requests before it would provide those documents. In our position, that was in breach of this paragraph 5, which specifically requested that if a party does not object, it should provide those documents. And again, I'm citing this to give the context to our position on disclosure, because in a normal scenario where, yes, some parts of the disclosure may have been objected to and would have gone to Your Honor's determination, other parts should not have and would not have gone to your determination and would have been produced and may have allowed the parties to progress with the timetable. But we are now in a position where even aspects to which there was no disagreement, they are still outstanding. Your Honor's document production order then gave the defendant 4 weeks to produce documents. Again, if you look at item 8 of the previous CMC, the previous CMC order had given the parties 14 days. Your Honor's DPO gave the defendant 4 weeks. The defendant's now asking for 7 weeks. And in fact, we don't know whether the 7 weeks will be complied with. The defendant has given rather lengthy explanations of why the delay has occurred. We disagree with the explanations. It was apparent at the time of the injunction delivery up order that the third-party IT provider the defendant was using at the time for its document disclosure was not a document disclosure specialist. We don't know whether it's the same entity that is being used, but in the documents, the defendant has referred to a general outsourced IT provider, which is the description they used back then. So it is unclear to us why the defendant has again used a non-specialist provider and why it took 4 weeks to identify problems. But be that as it may, this is a court proceeding with rules that apply and need to be complied with. The defendant has engaged a major law firm, which should be able to provide the resources needed to undertake a document review faster than would typically be the case in order to comply with court deadlines. So looking forward in the circumstances, and again, the defendant has itself now said it will complete disclosure by the 12th of July. So all we ask the court at this stage is to order that document disclosure must be complete by the date the defendant itself has said it will complete, which is 12th of July. And we also ask the court that should there be any further delay, the defendant should pay a sum of money into court pursuant to RDC 4.3, which allows the court, when making an order, to make it subject to conditions. We do consider that in light of the background I have referred, Your Honor, to, this is at this stage necessary in order to instill some finality to the deadline for disclosure, and also to assist us in the finalization of the remaining timetable, which is dependent on disclosure. Without some certainty, apologies.
When you propose or move for an order that in default, the defendant should pay a sum of money into court, pending what outcome? When money's paid into court, it's generally paid in pending the outcome of the trial or something else? Or do you mean that it be paid to the court as a sanction? Or what do you mean?
Well, we have not prepared the draft order with respect to this issue yet. And it may be that we should put this in a draft proposed order for your consideration, Your Honor. But either of the options that you've mentioned may be acceptable from our perspective. We simply consider that there needs to be some finality with respect to the date, and the previous dates have not been complied with. So we do consider that some sort of sanction needs to be imposed, and either of the two options that you mentioned could be considered.
I looked to you in the first instance to see what it is that you propose, rather than, as it were, for me to go away and think up what might be done. When do you think you can do that? Is it something you can do during the course of the hearing?
Of course. Well, we can certainly prepare the draft order in the course of today, and maybe once I have completed my submissions and my learned friend is making submissions, I can briefly consider whether we can do it in the course of the hearing as well.
Yes, it's in the first instance not so much the, as it were, the wording or drafting of the order, but the nature of it. And as say, is it to be an order which, in effect, if the defendant does not comply, that is, does not comply with the order by 12th of July, well, I'll go back a step. Should the defendant pay the money into court prior to the 12th of July or after the 12th of July? Secondly, if the defendant fails to complete and comply with the disclosure order by the 12th of July, is the intention that that money should be held in court on security for something? And if so, what? Or is it intended that it should be, as it were, forfeited to the court, paid to the court as a sanction for non-compliance? That's the principle that I want that you perhaps can think of when Mr. Doherty is making his submissions.
Absolutely. Thank you very much. And I will come back to you on this, possibly in rebuttal, if that's acceptable.
Yes.
Thank you. I should also briefly add before we leave the topic of disclosure that we do not know at this stage whether disclosure will include documents from the former employees. We asked the defendant to confirm whether it will. The defendant did not respond to us on this issue. In its email to the court, the defendant states that the former employees were asked to provide documents in response to the order on the 3rd of June. But at this stage, we do not have any explanation or any substantive reason as to what the response was. So we do consider that it would be helpful if the defendant's counsel was to provide an update regarding this issue, because in our view, having asked a month ago.
Interrupt you, Ms. Burt. Mr. Doherty, you could consider during the rest of Ms. Burt's submissions, I am going to ask you what the position is in relation to the employees, whether there has been a reply from them and what the position is. So just take that on notice. I'm going to ask you that. Back to you, Ms. Burt.
Thank you for the intervention. That is all I had on the first topic, which is disclosure. Very briefly, the second issue relating to witness statements. This the issue is the date for the witness statements was at all times also related to the disclosure. And now that disclosure has moved from the 2nd to the 12th of July, we do agree with the defendant's proposed date. The defendant proposed 16th of August for witness statements. So we have not had a chance to discuss this with the defendant yet, but we have no choice to some extent but to agree in light of the delay to the disclosure. So it makes sense in that sense to agree to the 16th of August. And our suggestion would then be to make up for this delay by shortening some of the trial bundle deadlines, to which I'll come in a moment as well, which is also what the defendant itself has suggested.
Well, before we get to that, Ms. Burt, the in your draft order, you had initially provided for witness statements by the 9th of August and any reply statements by the 6th of September. That is, I assume 4 weeks after the witness statements. You've told me that you agree that the witness statements should be completed by the 16th of August. Do you still need 4 weeks for reply witness statements, or could you reduce that to 3 weeks and keep to your 6th September deadline, or where do you see that?
Yes, that may well be possible. I think I'm just looking at the dates as well. I think the original reasoning for the 4 weeks to file reply statements, well, it still partly applies. I think the reasoning was that they were initially falling fully during the August period, which naturally is a holiday period, and that may apply to all the witnesses of the parties, and therefore I think some time was added.
I'd overlook what that's a holiday period, is it?
Well, August typically obviously is a holiday period for especially parents, and therefore there was a generic consideration with respect to any of the witnesses that may be less available.
When you say holiday period, you're referring to school holidays?
Yes. Yes.
Right.
School holidays being a period during which some of the parents that are also witnesses may be traveling. We have not specifically requested confirmation from any other witnesses. It was a generic accommodation for both parties to broaden it by a week, but certainly we could consider to limit that again, because I think that is correct that initially it was a 3-week period. And I think the reason why it was increased was because it was initially falling in August, whereas now the date does fall on the 6th of September. So yes, so basically we could retain the 6th of September, but extend the initial date to the 16th of August. I think subject to Mr. Doherty's use, that may well be possible.
Well, what we might do, I think we might do a somewhat unorthodox approach here, and I might go to Mr. Doherty about that issue before we move on. I know all of these dates, there's a knock-on effect from one to another, and Sometimes there's also a working backwards approach to things. Nonetheless, it is helpful, I think, in this case to look at what the position is into relation to witness statements, and particularly reply witness statements. My initial reaction was that 4 weeks seemed a very long time, but maybe as I was not giving consideration to school holidays and whether or not that's a factor. But I might go now to Mr. Doherty. What do you see the position in relation to reply witness statements on the assumption that the initial witness statements should be completed by the 16th of August? Is there any reason why reply witness statements couldn't be done by the 6th of September?
So I think our position on reply statements is that the window essentially needs to be a bit longer than one might see in a normal case. The main reason for that is, as I'll probably come on to later when dealing with submissions on expert evidence, partly it's down to the case on quantum.
Sorry,
and the
I'm
extent to which.
I'm going to interrupt you, Mr. Doherty, because as you would guess, my great length of experiences in courts in Australia, not in the DFIC, and I would ordinarily regard 2 weeks as being an appropriate period in major matters, because you have taken full instructions from witnesses in the first instance to complete their witness statements, and in those circumstances I would ordinarily expect 2 weeks would be ample for reply witness statements. Now, Ms. Burt has told me there's an issue about school holidays, and if you both take that view, then I'll listen to it. But I should just warn you that talking about 3 or 4 weeks as being the normal period is not cutting a lot of ice with me.
Sorry, I think either I misspoke or it didn't come across clearly. I think what I was suggesting is we were seeking slightly longer than the normal period. And the reason being, largely it's down to the case on quantum. And perhaps I can just take your honors what I mean by that now. So it's at the end of page 39 and the end of page 40.
In the bundle?
In the bundle, yeah. Sorry, it's just on page 40. We have the explanation of financial remedies that are being sought. So it's loss of profit, which is being calculated at a quite specific dollar figure, but there's no breakdown of what that means. But presumably what lies behind that figure is the claimant's assertion that there are X number of individual clients who have left, and we're saying that for each of those there will be a certain amount of damages to which that individual relates, because we have lost the profit of that individual. And so what that means is that there is presumably going to be an explanation from the claimant's witnesses at some point as to who each of those individuals making up that figure are, why it is that they have been said to have left AES, why it is they've been said to have gone to GSB, and why the circumstances surrounding that departure relates to inducing breach of contract and so on. So we have a series of particular allegations which haven't yet been set out in the pleadings. So the first time...
Doherty, you have a list of clients, you can look into all of those matters now. It's not as if you're going to wait until you get the claimant's witness statements and for the first time know what clients they're referring to. You've got lists of clients. I'm sure you'll be taking instructions. Your instructors will be taking instructions from your clients about them now. Indeed, will have done it long ago.
And I fully understand that. I suppose what my point is, I don't know what's coming by way of the claimant's witness statement, and if it's going to be a 100-page document with a detailed breakdown of what's said to have happened in respect of 80 individuals, it may well take longer than 3 weeks. Is why we had built in that contingency into the timetable. As Ms. Bird says, it's August as well. I do take instructions on what leave arrangements are. But that is the principal reason we've suggested the 4 weeks.
Who is it on your side who's going to be doing this work? Is it?
Well, I think
I've forgotten the name of the principal of your firm. It's Mr. What's his name?
Mr. Watnell.
Yes. Is Mr. Watnell unavailable in August?
No. So the issue isn't. Of course, we're going to have the first round of witness statements before then. It's more an attempt in lieu of a pleaded position to predict what's going to come in the witness statements and therefore what's going to need to be replied to. So it's an attempt to estimate how long that's going to take. That's why we proposed what we proposed. I take Your Honour's points on board, but we're just trying to build in what we think is a realistic expectation of how long it might take, so as the parties aren't coming back to the court seeking extensions or seeking to sort of satellite litigate agreements for an extension or anything like that.
We might
particularly where we've got fixed trial dates.
Yeah, Mr. Doherty, we might come back to that later, but indeed I will be asking you when we get to the subject why it is that the defendant has simply not complied with the court order about document production and not, as you then just foreshadowed, come back to the court asking for an extension and so on. But I'll just put you on notice that I'll want to hear from you about that in due course. I'll go back to Ms. Burt. Ms. Burt, does it make any significant difference to the rest of the timetable whether the date for reply witness statements is the 6th or 13th of September? You're on mute.
Thank you. Sorry, there are 2 mute buttons. It should not, if we are, if Your Honour agrees with our remaining arguments relating to the rest of the timetable, but if there are other accommodations made and extensions, then it would. So I think we may want to look at this holistically once we've done.
I'll provisionally take the view that the date is going to be the 13th of September, but I do want to make it clear that these are not aspirational dates. These are dates which must be complied with. All right.
Thank you, Your Honour. Thank you, Your Honour. And just very briefly, we've again heard a comment from Mr. Doherty that they are unclear as to which clients we are referring to in our particular claim. But again, we have repeatedly said it is us who are unclear about this. That is why we have requested all of this information and disclosure. That is why we are repeatedly saying we cannot prepare our expert reports because we still do not have this information. So we do not understand why there's this repeated comment that we would somehow know which of these clients are now with GSB prior to receiving the disclosure that we've requested in January. The next issue, which is the 3rd issue on our list, relates to the defendant's expert reports.
Can you briefly explain to me, I see the experts are going to be forensic information technology experts, and I've read how they've got some images from, I don't know, various computers and so on. What's the nature of the investigations, exercise and evidence which they're going to be given, which you anticipate they will give?
Yes, thank you, Your Honour. There are 2 issues relating to experts. One is relating to the period for expert reports, and the second, exactly as you allude to, relating to the forensic experts. So with respect to your question, the forensic IT experts are looking at, and I was also going to refer you on this issue to the particulars that Mr. Doherty just took you to. So he took you to another page of the particulars.
40.
If you could go to bundle 33.
Right.
You have paragraph 30 of the particulars, which is the relevant part of the claimant's claim, which addresses some of these allegations relating to forensics. Basically, the former employees had laptops and/or desktops as part of their employment, naturally, and we have some forensic evidence that confirms that they've taken some of this information or that they've accessed some of this information as set out in paragraph 30. I don't want to restate it. And that is the limited evidence that the IT forensic expert was supposed to corroborate. Because of course, at the moment, we have it contained in particulars. We can briefly address it and witness evidence, but primarily this is an IT exercise. It is a brief IT exercise. This is a brief report which merely looks to corroborate these items that we've identified in there. So it was at all times supposed to be a small part of the claimant's claim, because of course it relates to the claimant's part of the claimant's causes of action under the various claims that the former employees breached their previous employment agreements by taking confidential information. As part of that, of course, there are now various other documentary evidences that have been uncovered during the committal, which go to the same point. So, in our view, this point has already been made out in the evidence, and as such, this IT expert report has become possibly even less significant than it was at the beginning of the case. But nonetheless, there are these limited allegations relating to IT issues that can be helpfully set out in a brief report. And that's what we had suggested. Would Your Honor prefer if I now address you on the issue of the images in the bundle, and then I go back to the dates after that?
When you say the images in the bundle, this is the matter that's been raised in correspondence about the basis upon which the images or documents are to be disclosed to the defendant. Is that what you're referring to?
Yes. So this issue has just resurfaced, I think, a couple of days ago again. There was a significant discussion relating to some correspondence. In a couple of days, we received a response from the defendant saying that they wanted to raise this in the hearing, and we have therefore addressed this in our note.
You have, but then in the note of the 2nd of July, the defendant says it is unclear whether any resolution need be reached at the directions hearing. So that makes me reluctant to embark upon it if Mr. Dougherty is not going to advance it. So I understand your position. You responded to it because the defendant raised it, and the defendant now is saying they don't know that it needs to be raised. In those circumstances, do you need to raise it?
Well, it has been raised as such, and it does present a potential issue. I do, we did expect that the parties were able to reach a conclusion on this, but to some extent, since the parties are before Your Honor at this directions hearing, there may be some benefit to air the issue now, and it may be that following the discussion, the parties are then able to go back to this issue and resolve it. But it may be worth considering that there has been very significant correspondence on this issue. So if that is acceptable, I would briefly address you on this.
All right.
Thank you. So I've already explained what this relates to. And in January 24, because after the parties had agreed to this limited IT forensic evidence, we offered to provide these complete forensic images to the defendant, so that its forensic IT expert had early access to those images. The aim, of course, was so that the defendant would not, at a later stage, complain that it did not have early access, because we were already aware at that time that the defendant was concerned about the time periods it has for its expert reports. And ironically, in the note filed yesterday, the defendant is saying exactly this, because they have not received the images. They are now complaining that this is a reason for the extended periods for expert reports. So the reason we did not provide the images to date is because after our January 24 email, suggesting that we provide those images. We've suggested that the images are provided with an undertaking by the solicitors, because the images are, they include everything that the former employees who had on their laptops or desktops as part of their employment. So naturally, as you will anticipate, that is commercially sensitive information, that is information private to individuals that are investing with the claimant, and also various personal, relevant, and material information. So it was at all time agreed between the parties that that is the case. The defendant does not object that that is the case. And the claimant therefore proposed to provide these images on the basis of an undertaking that the defendant's solicitors would provide these forensic images to their defendant IT experts, and naturally barristers if necessary, but the defendant itself would not receive the full images. And the defendant agreed in principle with the proposal, and that's why then significant correspondence ensued where we were trying to settle the proposal, the undertaking. The undertaking, there seems to be some confusion, and it may be also helpful to flesh this out, because in yesterday's note it was said that the defendant said that we have not responded to its last proposal, or that we have not confirmed its final proposal. We have, of course, responded in our 2nd of May email, and that's the final email on this issue. And it is the defendant that then did not respond to that. That's bundle 155. So that was the final discussion between the parties with respect to the undertaking. And at bundle 155, at bundle 236, apologies, we have the actual undertaking that is our final proposed undertaking that we've sent to the defendant. And there were really just two issues that were where there was some disagreement. We have not received the substantive response from the defendant on these two issues. The first issue was that naturally, and this was in response to the defendant said, understandably, that certain documents taken from the images would be shown to the defendant to assess whether the documents are relevant for the evidence. And they may not be relevant for the evidence, but obviously there's privilege, and the defendant cannot tell us in advance what it's showing to the defendant. And we accepted that that's appropriate. But we said, in order to check compliance, after you submit your IT expert report, please provide us a list of everything that was shown to the defendant, but was not later included as an exhibit, because the idea was that the defendant is showing these documents to the defendant to consider whether or not they should become exhibits relating to the IT expert report. So that was one issue of disagreement where we had come, what we thought, to a sensible compromise in response to the defendant's suggestion. And the second issue was relating to the provision of the images to the IT experts and barristers if needed. I think there was some agreement that the defendant's solicitors would request confirmation from the IT experts that they would comply with the undertaking. But one addition that we've made is that rather than just request confirmation, they also do not provide the images until they receive the confirmation. So this is it.
See, understand this. The request is that anybody, IT expert, the barrister, who is going to receive a copy of the images should first give a confidentiality undertaking before receiving them. Is that the proposition?
We've asked for something more straightforward than that, a simple confirmation that they will comply with the undertaking. It was more straightforward on the basis of the fact that the undertaking is signed by the defendant solicitors, and as long as they've obtained a confirmation that the third party will comply, we were comfortable with that.
All right. So you asked only, no, I should drop the word only. You ask that the person who's going to see the documents, the IT expert, any barrister, should confirm to the defendant solicitors that they will comply with the undertaking. Is that what you ask for?
Yes, I am just looking at at page 236, the particular provision, sorry, 237,
237.
item 7 of the undertaking.
Right, to disclose.
Item 7 at page 237, you will see in black as well as
All right.
yeah, that's what we had requested. And the yellow highlights are the bits that were the new changes that we've made, to which we have not received a substantive response. The rest was agreed.
Well, I'll hear what Mr. Doherty says, but for the moment, I can't see what's wrong with that.
I think that concludes what I wanted to say about the undertaking. In our view, there should be either an undertaking which the parties can agree on terms that are agreeable to both solicitors, or the alternative must be that the forensic images are not released in full, but are released partially on the basis of the relevant documents. To some extent, a lot of this discussion is really moot, because, as I said at the beginning, the IT experts will be looking only to corroborate those very limited areas that we've identified in our particulars. And it is unlikely that this issue is going to be significant. But of course, we accept that we need to foresee all possibilities at this stage. But in our view, this discussion is largely moot, because it is unlikely that there will be significant exhibits or the like that will even have to be provided to the defendant. And the forensic images naturally are just that. They are images that the defendant itself is not able to review.
Yes. Just going back to that, I've understood, and I may have misunderstood, but what I think is the position is that your IT expert or your people have taken these images, and the images include much material or some material which is irrelevant to any matter in issue. Now, ordinarily, of course, one would redact them, but I understand what is said, that for some technical, practical reasons that can't be done, so that the images which must be looked at will contain irrelevant material. Is that the position?
That's what I understand the technical position to be. I have actually not considered how one would redact an image, but I had possibly rightly or wrongly assumed that was the case. And of course, not just the relevant information, but also importantly, commercially sensitive and private. But yes, but that's my understanding.
All right, now.
So that's all I wanted to address your Honor on respect to the IT experts' data, and then second, there is the issue of the dates for the expert reports.
All right.
Thank you. So on the dates, this is a matter of significant contention between the parties for some time. It was argued at length at the CMC. And prior to the CMC in correspondence, the defendant was eventually unsuccessful and has now opened the issue up again. All I wanted to say here is that we are really just asking the court to reimpose the same periods the court already imposed at the CMC. On that basis, the claimant will file expert reports 3 weeks from the close of witness evidence, which I should say is a short period of time, considering that, I can only repeat myself, we do not have disclosure. So until our witnesses have considered the various clients and the documents that the GSB needs to disclose, our experts cannot finalize their reports. So 3 weeks is a short period of time for the experts to turn that around, as much as the defendant's counsel is concerned about their own experts. The defendant will then have 4 weeks to prepare their reply reports, taking into account our expert reports. That is what was ordered in the CMC. Even though I should also say at the CMC, in fact, the judge ordered 3 weeks, and we had agreed to 4 weeks because, again, there was a holiday period. There was I think, half-term school holiday that was following at the time, and we had or agreed to extend it to 4 weeks. And we are comfortable to, again, stick to our agreement at that time and now keep the 4 weeks, even though now there is, as far as we are concerned, no additional holiday period that falls through this time period. And as such, in our view, the defendant's actually now getting additional time than it was at the previously stated dates. We are also somewhat confused as to what period the defendant is requesting, because it seems in its latest email from its solicitors on the 28th of June, it said 5 weeks, whereas yesterday's note appears to relate to 6 weeks. So it's not exactly clear how much time the defendant is requesting, but in our view, 4 weeks is the maximum here. And I should also say that the defendant has said in the note, rather than seeking an extension later, they would like to ensure that they have additional time at this stage. Our concern is that granting the defendant additional time at this stage does in no way guarantee they will not seek a further extension, as they have done on many other occasions. And our concern again is, if we extend the periods now, then extend them again due to an extension, that does jeopardize the hearing dates. Obviously, there are also various other dates that need to be, that may be extended. I was going to move to the next issue, but
before you do, there's another in relation to the expert reports. I find it very helpful when there are experts, for the experts to confer between themselves and produce a joint report setting out the matters on which they agree, and where they disagree, setting out succinctly their disagreement and the basis for their disagreement. Now, this timetable doesn't build in such a process. Is that simply because the parties didn't get round to it, or is that a result of a considered position?
Thank you, Your Honor. I don't think that there was a considered position on this issue. We had agreed with opposing counsel for a date for the experts to meet to discuss data. So there is a date where the experts can confer before their reports are prepared on data points. And we do think that that would be a useful opportunity for the experts to start discussions and to start considering how they can make sure that they are, to some extent, presenting arguments on the same basis, or analyzing methodology, let's say, of the arguments from the same
yes.
data points
Well,
at the very least. But yes, you're absolutely right that there could also be a joint statement. We would not be opposed to that.
Well, on your timetable, you have the last supplemental report produced by the 6th of December. Now, I'm not sure whether any of the other directions affect the question of a conferral, but it seems to me you could provide for a further direction, providing that the experts should meet and confer and produce a joint report setting out those matters on which they agree, those matters on which they disagree, and where they disagree, the position of each of them, and succinctly why. And that could be done, I would have thought, by the 20th of December, could it?
Yes, in general, we are agreeable to this. We would, if that's acceptable, just double check the dates with our experts as well. But yes, absolutely, that is a good way to ensure that we put together the best possible case in front of you for the trial. Yes. So we do in general agree that that would be a useful step.
All right. All right. Well, I might go then to Mr. Doherty about the experts. Mr. Doherty.
Thank you, Your Honour. I suppose there are a couple of bits to work through on our position. And perhaps just if I can refer you to a couple of parts of the procedural history to shed some context on that. I think some of it we've discussed already. But certainly my understanding of what the expert reports are intended to cover. So we've got the forensic report, that's supposed to be an investigation of data contained on the claimant's systems. So it's not live access to the system. So when we're talking about an image, I think it's an image of the data that has been taken and then can then be taken away by the experts and probed. And my understanding of that is they can look at metadata, they can see when documents were accessed, by whom, whether they were downloaded, and so on. And then, of course, quantum, which, as I understand it, is to piece together what is in the particulars of claim actually quite a precise figure that is pleaded for loss. And we don't know what the explanation is, but presumably there's some methodology behind where that quite precise $17 million figure comes from, or whatever the updated figure might be. And presumably that is.
Mr. Doherty, the reference in paragraphs 5 and following to expert reports is to cover both the IT experts and the quantum experts, who I assume are accountants or something of that ilk, are they?
And I think there are probably common issues that affect both, although one might see that the position of the technical expert is slightly different insofar as one assumes there's no reason that they can't simply do the work that they need to do now. They've got the materials that they need. That is, the image is what the work they're doing is not contingent on disclosure and so on.
Let's go back a step. Could you just confirm, are the expert reports referred to in paragraphs 5, 6, 7, 8 and 9, are they referring to both IT experts and quantum experts? I see Ms. Burt nodding.
Yes.
Yes, okay. All right, thank you. Now, back to you.
Yes, of course. So as I say, given the nature of the reports, it must be right that much of the information that they're going to analyse is in their possession. So the technical analysis of what's been extracted from the claimant systems requires the expert to look at the claimant's systems. And similarly, the quantum analysis for how the claimant has reached its figure of loss is taken from presumably a composite of the people who have left, what their assets under management were, what profits were derived from that, and presumably a forensic accountant will apply things like discount factors and so on. What we say about that is that the claimant is in a position where it has the information it needs to prepare its reports. By contrast to that, the defendant's position is, and I hear what Ms. Burt has to say about it being a relatively straightforward report. We have no idea. We don't know what's coming down the track, particularly with the forensic IT report. And the defendant's in the position of going into the preparation of its own expert evidence pretty much blind. We don't know what the scope of the work being undertaken is. We don't know how time consuming it's going to be. And on the quantum side, we haven't had a prior.
Can I just stop you there, please? So far as the IT evidence is concerned, this timetable proposes that the IT expert should meet on the 23rd of July and discuss methodology and the data required. Now, I assume there's nobody has proposed that there be any prohibition upon the experts conferring with you about that. And if so, you will know on the 24th of July what the methodology and data required by the experts for their report. You're not going to be in the dark, as I think your expression, until you receive the claimant's reports. You're going to know the methodology and the data required on the 24th of July.
The discussion, I think our point is more that the claimant's expert was instructed in December 2023, I believe, and provided with the forensic image, as we understand it, which was taken in January 2024. And at the very least, we can see, and I can give you on a page reference if you want to look at it, but at 153 of the hearing bundle, we have reference in an email from the 20th of June from the claimant's solicitors, which says,
Can I just stop you there? If this is going down the road, they've had this amount of time, we should have this amount of time. I find that a most unhelpful argument, if that's where you're going.
That's not quite where I'm going. I think what we're saying is they've had a large amount of time. They know how much work is involved. In June, we've had reference to the claimant's forensic IT experts have interrogated the forensic images of the devices, which were the subject of the report's CLA, and they provide some information about that. And what my learned friend is telling us about the forensic IT report is that the date we proposed of shortening the date for providing their expert reports doesn't work, because their expert still has work to do, and they'll need, I think it's 3 weeks following the closure of witness statements to do that. And if that's right, and they've already been working on the report at least as of 20th of June, one expects that probably the work that our expert is going to have to do is going to take longer than that. And indeed, the estimate that was given.
I'm not sure I followed that. I thought the point that was being made by the claimant about time after the witness statements was so that they see what your witness statements say, not that they need to use the information they've already got.
Well, I don't know. One struggles to see how a forensic report, which is looking at how the specifics and the technical issues as to how a particular document is accessed and so on, has any bearing on either the disclosure from the defendant or witness evidence.
Let me cut to the chase as I see it. On the 23rd of July, you and your IT expert and you are going to know the methodology and the data required for the reports. On the timetable put forward by the claimant, you will have until the 25th of October, 3 months in which to prepare your report, and a full month after you've received the claimant's reports. Now, I can't for the life of me see why that's not adequate.
It's because it's a responsive report. We don't know what is being alleged, and we don't know what information is going to need to be probed. So we'll have got an understanding of how their expert is going to set about their task, but we don't know what that's going to yield or how much delving into the system is going to be required.
You don't, it doesn't work that way, Sidoti. We've all done these cases before. Your expert is going to meet with their expert on the 23rd of July. It's not as if nothing will happen on your side between then and the 27th of September. Your expert is going to meet with their expert. He's not just going to sit there silently. He's going to ask and talk about it, find out what the methodology is, what the data required is, and is going to ask questions and find out what he needs to find out in order for him to be able, him or her, for them to embark upon their report. So it's not like they don't start, your expert doesn't start their report until the 27th of September. Their report should be or the investigation for their report should be well underway by then. Now, it's useful for the reports to be sequential rather than there be an exchange of them, so that your expert can address the matters that are put in the claimant's report. But as I've said, and I'm not going to repeat it again, it's not as if your expert starts from scratch when they get the claimant's report. So unless you've got something else to add, I'm not persuaded that you need more than 3 months after the 23rd of July and more than 1 month after you get the claimant's report in order to put on your report. And can I add this? If it becomes the case that on the 24th of July, after your expert meets with their expert, it is then apparent to you on a proper basis that you're not going to have sufficient time, then that's when you can and should make an application to the court for an extension of time. Similarly, if after you receive the claimant's report on the 27th of September, if on a proper basis, you come to the view that you don't have sufficient time to put on your report by the 25th of October, then of course that's when you should make an application for an extension of time, explaining all the work that has been done in the meantime and why it is that it can't be done by that date. But in the first instance, I have to set what appear to be reasonable dates. Unless there's something further new you want to add, those dates appear to me to be reasonable.
Sure. I think that the specific point here has more to do with the precise nature of the exercise here. One, of course, so for example, if one was looking at, say, a medical case where you have two experts who are looking at a leg injury and what the prognosis of that is, of course, you can prepare those reports in tandem. They might be sequential, but you can do work on it. Here, what's being provided is access to a image of the whole of the claimant's system. So to interrogate that, of course, you're looking largely at a needle in a haystack, which is the activities of a couple of individuals. And partly the nature of the exercise and the responsive report is going to be to probe specific allegations that are made, but not necessarily pleaded as against the particular former employees. So the work that will need to be done will invariably need to be responsive in the true sense, rather than there being two sets of work that can start at the same time, and it's just that you have sequential exchange. So that's the first point. The second point, as to having 3 months from the 24th of July, somewhat ties into whether or not the defendant's expert is envisaged as being given access to the materials that they need to access in order to undertake that scope of work by that time. And really, that's the reason I flagged this as not necessarily for your decision, but as an issue which may impact on timetabling, because the discussions which took place from January this year didn't proceed on the basis that the defendant is never going to be given access to this set of data and these documents. That seemed to be common ground. So the history of that position was that prior to the CMC back in January, the defendant had made the observation that forensic IT experts had already been instructed and reported on certain issues in the onshore court proceedings. And so we questioned what would be added to that by reports in this case. The claimant said that they wanted to just forensic expert evidence. This is a documented 244 of the bundle, if Your Honour does want to go. But what they say is the claimant's case is that the former employees took information. It's a core issue in dispute that is relevant. The claimant's case in this regard will be evidenced by way of forensic IT expert evidence.
Yes.
And the its exegesis will be reasonably required to resolve proceedings. And what they also said was we can't predetermine what information data they may wish to review, but that the defendant's expert would be entitled to review the information and data relied upon pursuant to RDC Part 31. Following that, and in order to try and avoid having an argument about the issue at CMC, there's an attempt to reach common ground. What the defendant says is we'll not contest the proportionality or relevance of expert evidence, provided we're given equal access to the information that's being interrogated. And on the 13th of December, that proposal was accepted in unqualified terms. So I'll quote this because it's not on the bundle. What the claimant said was, as to the data relied upon by the forensic IT experts, as is typical in such proceedings, the experts will be given equal access to data to prepare their reports. We expect the experts will use image data taken from the claimant's systems. Our position is that equal access means just that. So prior to the CMC, when the directions were agreed, contingent on this common position having been reached, we weren't informed by the claimant that we have to tell you what documents we think the expert may or may not find relevant, because we don't know. We haven't required that they disclose to us what discussions about information they've had with their expert, or what list of documents they have considered might be relevant, but ultimately didn't appear in the report. So there's no filter that applies that way. And of course, Your Honour will be aware there are a whole host of rules dealing with experts' duties, but also parties' duties to the court. So, for example, RDC 31.5 explains that experts have to be independent and uninfluenced by pressures of litigation. 31.7 says that experts must consider, quote, all material facts. And 31.21 says that if you're going to rely on expert evidence, you have to provide copies of materials that are relied upon by the expert in their report. In this case, that would be interrogating the claimant's own system, because that's the scope of what the report is intended to do. And there are, of course, protections which are built into the RDC when it comes to use of documents in litigation. So, of course, you've got 28.64, which says that if documents are produced during the course of litigation, they can only be used for proceedings and not for ancillary purposes. So the parties had reached the common position that experts would be given equal access. Subsequent to the CMC, what we then had was the claimant seeking to say, well, we want to have you sign up to an undertaking and you will do that, but we'll give you, as Ms. Bird said earlier, and as was referred to in correspondence as well, early access to the information. So that was, we'll give it to you with standard production rather than later. And the first point in that is, I don't think that any party was operating under the impression that the materials would never be released. The undertaking was dealing with getting them early to try and facilitate a smoother process of preparing the report. That hasn't been agreed for various reasons, and I suppose I'd probably ought to take Your Honour to some of what those are, because you saw the undertaking earlier.
Can we skip some of the history and get to the point where we are today? Why is it? Let me go this way. You've referred to, what is it, 2864, the traditional Harman undertaking.
Yes.
As you're well aware, in cases, in addition to that sort of undertaking, confidentiality regimes, confidentiality clubs or rings, or what the various ways it's described, are not unusual, if not common. It's not as if that's a strange or rare beast. Where IT experts, other experts, or the solicitors are to be shown documents which are highly commercially sensitive and so on, it is not unusual for there to be restrictions upon access to them. In this case, as I understand it, the particular point that has been made is that some of these documents, for technical reasons which I don't understand, but I'm told, the disclosure of the images will involve disclosing irrelevant material, and that is significant in this case. Now, of course, some issue might arise whether it is irrelevant or not, but in the first instance, the fact that the claimant's IT expert will disclose to your IT expert material which the claimant says is commercially sensitive and irrelevant, on the face of it, is a good reason why access, at least initially, should be confined to the IT expert and possibly to the solicitors and possibly to barristers, but not to the defendant. Now,
Your
as I
Honour,
said, sometimes it might arise that the IT expert or the defendant or the barrister might say, I don't know whether this is relevant or not. We need to take instructions from the defendant. If that arises, that can be dealt with at the time it arises.
Your Honour, and what the undertaking was limited to dealing with, or if those were the simple terms in which it described, that would be no issue. And in fact, that's what we said from the outset. So when the undertaking was...
What's the argument?
The issue is the additional levels of
all right. What is
complexity imposed on the terms of the undertaking, which...
Take me to whatever it is you object to.
So
Sorry, you've gone mute for some reason, Sidoti.
it's because I've pressed mute. The current iteration of the undertaking is at 235.
Yeah.
So January, we said no objection in principle, send us an undertaking so we can review it. The initial concerns that came back were that effectively you have to tell, or there's a duty to inform of what documents are being put to the defendant to check whether they're relevant or not. And the concerns there are, one, the potential restriction of disclosing to our client relevant documents.
Can you tell me which paragraph you're going to?
Yeah. So the current paragraphs are so paragraph 6. So paragraph 6A, first of all, says that forensic images should only be accessed by the defendant's solicitors, counsel, and experts in the first instance. The intention of the parties is that there's a mechanism for, if documents are discovered to be potentially relevant, that those can then be put to the defendant. And if it was as simple as that, as I say...
Well, just let me follow through. So that comes down to Romans 4, does it? With respect to exhibits, potential exhibits, which the defendant may share, which the defendant's IT experts, which the defendant may share. Something, am I missing the grammar there?
So I struggle to follow the amended text. I have to say on this, I think what the proposal that was last put by the defendant was, if materials are identified which are potentially relevant, that it would be possible to put those materials before the defendant to take instructions on, but without putting the whole of the image or the whole of the data set before the defendant. So I think the intention is to carve out only materials which are relevant or potentially relevant for the purposes of taking instructions, which is all fairly straightforward. But what we're not going to do is take, I don't know, whatever it is, a USB or a hard drive and hand the whole thing over to the defendant. The several issues which arise in the undertaking are, one, the notification provisions. Previously, it was suggested that prior notice had to be given of what the documents were, and we suggested that that's problematic from a privilege perspective.
I don't want to talk about disputes which are no longer put forward.
Yes, well, it's still potentially a live issue insofar as what is sought is not only lists of what ends up in the expert report, but anything that's gone to the defendant, because the problem with that is if something is identified as potentially relevant or it's flagged and it's put, that's potentially still covered by privilege because you've identified materials which perhaps the other side haven't identified, and you have to go take instructions on that without needing to explain to another party to litigation precisely what your thought process is behind doing that. So there are still live privilege issues. Then what we have is also the new paragraph 6B, which seeks to place quite extensive obligations and subjective interpretations on the defendant's solicitors.
So it's where we... Let me just read it before you start telling me what it says. I'm sorry, I'll just take a minute. So the we, I'm sorry, who's the we in this letter?
We would be the defendant's solicitors.
Okay. So it says, when we provide to the defendant potential exhibits to the reports of the defendant's IT expert, we shall provide you, that's the claimant, with a list of any such potential exhibits after the filing of the report. So does that mean it includes both exhibits to the reports and other potential exhibits, which were potential exhibits but didn't wind up as being exhibits? Is that what it means?
I suppose to put it in prosecution terms is what you might call unused material, I suppose.
Yes. Okay.
But it's something that's been identified where the need has been seen to take instructions from the client, but ultimately hasn't been relied on. And so
Yeah.
the first point we make is to say that there are probably still privilege issues with that. So there's the timing issue, but there's also a privilege issue. And then there's the second part of this subparagraph B, which then says, who will take reasonable care to avoid disclosure to the defendant of material that is or may be commercially sensitive, private, personal, confidential, and or which may cause harm to the claimant and or related third parties, such as former employees, if not kept confidential. And it's
Yeah.
not difficult to see why that is really quite problematic, not least because the defendant solicitors aren't a party to these proceedings. They operate under professional duties and duties to the court, which I think one can reasonably expect are going to be complied with without them putting some positive obligation to take reasonable care to avoid disclosing commercially sensitive materials. But when one considers what the case is actually about, one struggles to see how it can possibly
All
be
right.
workable because
On the face of it, Mr. Doherty, I can see your point about the second part of that paragraph. Tell me what it is you propose. That in the first instance, the IT expert, your solicitors, you and other counsel may be provided with any of the relevant documents, but not provide them to the defendant. What after that do you propose, if anything?
so to the extent that instructing solicitors or counsel or the experts during the course of that process identify materials which they deem to be relevant or potentially relevant such that they need to take instructions, that they're permitted to show those documents to the defendant to take instructions. But no one is proposing that we're going to hand over the whole of the data set, the whole of the imaged files to the defendant. That's really what the undertaking is supposed to cover, without putting in either responsibility for the defendant solicitors for the acts of third parties or some sort of veil of liability. And as Ms. Burt says, that their reason for doing that is to try and police the undertaking, which, in all fairness, Your Honour may appreciate offers relatively little comfort to the defendant solicitors in light of the overall context of the proceedings and the committal applications that have been made. They want to take, understandably, quite great care over what they're signing up to. So really, it's that second sentence, and it's the timing issue. It's the subsequent disclosure of materials that have been passed over we deem to be unnecessary. We think that a solicitor's undertaking should be treated by a counterparty and the court as being something that can be relied upon.
Undertaking to do what?
An undertaking not to provide the imaged materials to the defendant and not to provide them with material that is deemed to be irrelevant.
No, but what is so I'm trying to look at the positive part. The undertaking that you're proposing is that you would just tell it to me again. What would you undertake to do and not do?
I should say that the draft you see here, the red line, shows you our previous version as against what's been amended. So what we're saying is we agree not to provide the image device to the imaged data set to the defendant. We will not provide irrelevant material. The only material that will flow to the defendant is something which is been identified by the expert or legal representatives as relevant or potentially relevant, such that instructions need to be taken. And what we're saying is that It's hard to read through, but if paragraph 6 says our firm irrevocably and unconditionally
So,
undertakes to you,
I didn't hear the number you said. Paragraph what?
paragraph 6.
Yeah.
So what the original text said is our firm irrevocably and unconditionally undertakes to you that the forensic images will only be accessed, viewed, and copied by the IT personnel, by barristers, by independent forensic third-party experts. And then the subclause to that had originally read, unless we reasonably believe that any part of the relevant forensic images are relevant and material to the proceedings within the meaning of RDC 28.17 and 28.28, and accordingly, the same should be disclosed to our clients.
I see.
So that's what we had proposed. And the major difference then between the parties is, one, as I say, this further obligation to take reasonable care, which we say is unworkable, and two, the duty to notify, which we say potentially encroaches on privilege. We say that a solicited undertaking in the form we have offered should be acceptable to another firm of solicitors who understand professional duties and duties to the court, and can have confidence that the undertaking is going to be adhered to.
Yes, I see.
That's been the position. I think it was the 28th of April that this was, or 15th of April, this was provided.
And the amendment to paragraph 4, whose proposed amendment is that? Crosses out the words reasonably believe that and so on, and instead says with respect to exhibits and potential exhibits to the reports of the defendant's forensic IT expert, which the defendant may share with the defendant.
Yeah, that's the claimant's more recent amendments. So that's what has come back as of 1st of May.
All right.
So what we said is there's an undertaking which should give more than adequate comfort already before the claimant has been there since the 15th of April. And the timetable issues, which I'm sure we're going to come on to discuss,
Right.
are, from our perspective, we proceed on the basis that the information is going to be provided, because that does appear to be an issue which has the potential, at least, to cause delay if it's not dealt with.
Yes. All right. And when it says disclose to our clients, I assume, or perhaps I shouldn't assume, ordinarily that would specify a person or persons, not simply the defendants at large. Is that your intention?
I suppose it doesn't currently. I suppose it's difficult to know precisely who the person it needs to be directed to is until one identifies what the document is. Because I suppose if one were to include, say, Mr. Watnall in there.
In my experience, the way that is usually dealt with is that within a confidentiality ring or club or whatever you want to call it, there is a named person. And then if for some reason a party considers it's necessary that somebody else have access, you come back, you first of all confer, see if agreement can be reached, and if necessary, come back to the court to have an amendment to add somebody to the list. But it's ordinarily not done by just having a blank reference to the party, which would include presumably all your salesmen and so on. In the first instance, I would expect the reference to be to a person, or for some reason it might be your CEO and an IT expert or something of that sort, but I would expect the persons to be named. And as I've said, if that turns out to be inadequate, you'd seek to add somebody to it.
Yeah, so I suppose the potential issue one can foresee in the specific context of this case is that what the IT expert is going to be looking at is actions undertaken by former employees during a course of previous employment. So to the extent that something crops up and one doesn't know the relevance or not, there's a good chance that the relevant people who are going to be able to give instructions about what the thing is are the former employees rather than the CEO of GSP, because of course the CEO of GSP doesn't have direct knowledge of either the particular communications or of the systems. So one could see the problem being that if anything is identified, there's going to be an immediate problem of instructions not being able to be taken from the relevant individuals. It may well be that if there were to be a list of the people it could be shown to that were limited, it might just be the lists of, say, a chief executive or an IT provider, or but to include the former employees, because one can already foresee that they may need to give instructions.
Well, of course, Ms. Burt will probably resist the form in which you've put that undertaking, as they have previously, but my current view, without making any ruling on it, because as I understood it, what you've invited me to do is to address this issue to see if you can reach some resolution. My current attitude is that it ought to be sufficient to have an undertaking in the form which you have proposed, Mr. Doherty, in that it can be disclosed where the defendant solicitors reasonably believe that any part of the relevant forensic images are relevant and material. I think probably there might be an additional, the wording might be something to the effect, and it is necessary to disclose to them in order to take instructions. I think it might, it should be narrower than simply relevant and material to the proceedings. I think it ought to be confined to where it is necessary to take instructions. And then secondly, it ought not to be simply to the defendants, it should be to named persons. And in the first instance, I would see it as being confined to your CEO, and if necessary, if you have a chief IT person or somebody in that position, to that person, but not to others, and in the first instance, not to the former employees, because they are engaged in sales activities, and for the reasons that have been explored earlier, I would fully understand the claimant to be to consider that to be commercially damaging information in the hands of the former employees. So in the first instance, I would see it as being confined to your CEO and IT person, and if it turns out that that is insufficient, that it is necessary for you to take instructions from others, then, as I've said, you would confer with the claimant, and if you don't reach agreement, then you'd come back to the court to seek a variation of the undertaking on evidence provided to the court about why it is necessary to take those instructions, not simply the sort of ipsit dixit that it is necessary.
Sure. One would just pausing there to think it through, because of course, at some point the expert is going to have to produce their report, and if they have deemed a document not a document that they need to take instructions on from any particular person, but at the point in time at which they determine that the document is relevant and that they want to refer to it in their report, it is going to be disclosed in the course of proceedings in the normal way, at which point, yes, presumably one wouldn't envisage there needing to be special permission or prior permission of the court for that to happen. This would only be if the document is to be shown without being exhibited, for example.
Well, I would expect it might be. What sometimes happens is that if a document is attached, incorporated in an expert's report, and the other party takes the view that it is for some reason commercially sensitive, it would seek to have an order that remain confidential, so that there ought to be some mechanism built in, for example, that the report, in such a circumstance, the report not be disclosed to the defendant until the claimant has received the report and has had an opportunity to consider it, and whether it will seek confidentiality in relation to any of the exhibits to the report, which could then be dealt with in the known circumstances, not on the basis of some hypothesized view as to what they might be and why it might be necessary or not necessary for the defendant or people within the defendant to see it.
I'm just trying to think it through for a second, Your Honour, just because my pause and my hesitation is if, for example, the assertions have to do with, say, Mr. Ritchie accessed this document on this date, and the defendant's expert wishes to probe, say, metadata around an assertion contained in the claimant's expert report around that, and wishes to say something along the lines of, I disagree with the claimant's expert about this document being accessed on this date. For this reason, I can see that Mr. Ritchie did Y or Z on this date. I don't know what the content precisely of that looks like, but my pause is that the expert itself might not need to speak to Mr. Ritchie to be able to make an assertion like that, because all they're doing is probing the metadata. And what I'm conscious to avoid is a circumstance in which the expert themselves feels fettered in the provision of their professional opinion by the terms of an undertaking, purely on the basis that there might be some subsequent assertion that whatever he's saying is confidential. I mean, the expert needs to be able to present their report using all of the relevant materials. I fully understand why, if there is information which is irrelevant or deemed to be confidential, there should be a filter before it actually goes to relevant person to take instruction. But if this isn't a case where the expert feels the need to take instruction, they just deem it straightforwardly relevant and they want to include it in their report, they ought to be able to include it in their report in the normal way.
Yes, and that would be catered for by some provision that the report be provided to the claimant before it is provided to the defendant, so that the claimant would then have the opportunity, if it considers there is some material which is commercial and should remain confidential, to seek a confidentiality order in relation to it. But the expert would not be restrained in any way from expressing his or her opinions on the basis of the material which the expert has access to.
Yes, Sean, noted. I imagine what will happen now is the parties will engage and seek to deal with the undertaking issue in short order, but hopefully this doesn't come back before Your Honour.
Yes. Yes, sorry, carry on.
Subject to that, I think it somewhat circles back to the issue on dates, because one can also see. I suppose let me just be clear first of all on the defendant's position in this. I mean, the defendant really has no interest in dragging heels and increasing costs. There's been a lot of time and cost incurred in these proceedings already. I mean, I know what my learned friend says, and the claimant makes its usual submissions blaming the defendant for most things, but to completely ignore the effect of the failed committal application and its consequent effect on trial dates is a little bit unrealistic. But we have a trial in February. What we're seeking to do is to put in a timetable which allocates reasonable time for the steps to be carried out, so that the parties aren't coming back to court. And so it's with that in mind that our proposals had all substantive steps being completed in 2024. So that's around 2 months before trial takes place, which builds in ample contingency, which hopefully isn't necessary anyway. But what is going to be clear, and Your Honour, I'm sure, is clear on this.
That's right, except that I wish to add in an extra step, and that is the conferral of the experts, and that should take place by the end of the year. And to do that, I think you have to use the claimant's timetable in order to be able to then fit in a conferral of the experts after the last of the reports.
Yes and no, because of course in our version of the timetable, the point we have made is to say that the claimant has been able to work on both of its reports from the inception of this case, and it doesn't need that quite lengthy window after witness statements have concluded, for example, to provide its forensic expert report, because it's already working on the forensic expert report. And if 4 weeks is enough time for the defendant to do it, then there's not really any reason why it couldn't be disclosed even in a couple of weeks. But even assuming it comes a week after witness evidence, one struggles to see why that's not possible. Similarly, when it comes to quantum evidence, the claimant has pleaded a specific figure. It's obviously calculated that figure somewhere. An accountant presumably will take the basis of that calculation. They'll apply accounting factors and discount factors to turn it into more accurate damages sum, perhaps. But again, there's no reason why they would require the 3 to 4 weeks post-witness statements to deal with that.
Doggedy, I'm looking at your minute. I thought both parties provide the claimant shall file their report by the 27th of September. I thought that's what that is what you say in your document, isn't it?
Perfect. I'm just opening up the page. I think we had shortened
your second case management order, page 175, I think it is in the bundle, and it says at paragraph 5, the claimant shall file and serve its expert reports by no later than 4 p.m. on 27 September. Because what happens thereafter is where the differences arose.
The page I'm looking at is also 207, where we had proposed a shortening of the timetable. And I suppose the point we would make is if there is...
Sorry, is mine out of date or is yours out of date? The document, let me just turn it up. 175 is, I think, the document I was looking at. See if I can find that. Yes, I can't see a date on it, but that's the document I understood to be your current document.
You were looking at 175. Sorry, let me...
Have I misunderstood?
It's difficult where they're placed in the bundle. I think my understanding of where the latest position is, which shows in track changes, what the dispute between the parties is 207.
207.
But again, it's not.
Right, let me have a look at that. I might have missed that. Right, so that's a document, and we've got black, red, and blue. What do you understand to be who's the black, the red, and the blue?
So red was what we had been posing, and then the counter proposal comes in blue.
All right. Well, paragraph 5 seems it was just black 27 September. Nobody argued about that.
Yes. So what we had been putting forward was the suggestion that we'll need 6 weeks. The other side say you don't need 6 weeks plus. We need this amount of time to prepare our report. What we're suggesting is if the point identified by Your Honour, which is that you want to include a further step for combined reports, one area where you can see there being a time saving in expert reports is the current gap being proposed between the 6th and the 27th of September by the claimants. Because given that the reports are underway and are being prepared, if more time needs to be found to strike a middle ground in the time the parties say that they need to prepare, that seems to be one space where it would be possible to find that time.
All right.
And as I say, just to come back to it, Your Honour will be clear. I don't think either of the parties is going to come before Your Honour seeking to vacate the February timetable. We've got a long run in until trial now. There's a lot of time to fit in these steps, and no party is going to come to the court in due course saying it's not possible. Can you please vacate this trial? I don't think that Your Honour would thank us for doing that.
It might be my misfortune, but in a previous life, 20 years as a trial judge, it was not unusual for that to happen.
I'm sure it was unusual for it to be granted.
It was very unusual for it to be granted.
And we're obviously cognizant of that, but I think both parties are at the point now where they want to get the steps carried through. I think what we're trying to avoid is satellite litigation coming back to the court and correspondence, because if there's one thing this case doesn't need, it's more correspondence.
All right. I'll go back to Miss Burt. Miss Burt, there is no great science in this, but seeking to be some flexibility, is it realistic to expect that you could complete your expert reports, say, a week earlier by the 20th of September?
Yes, we are happy to agree to that as a compromise in order to help the timetable issues and create additional flow towards the end.
All right. Well, what I am looking at is I'm looking at the timetable, which, well, perhaps I should have gone to that page that Sadohi took me to, 207 and following, on 208. Then I'm looking at the paragraph 4 would read the 23rd of July. Paragraph 5 would change to the 20th of September to give the defendant an additional week, so that the defendant has, and the defendant then is 25th of October. So I've given the defendant an additional week. In my view, Mr. Doherty, that is sufficient time. If after the IT experts have met on the 23rd of July, if at that time, after conferring with the IT expert, you form or your solicitors form the view that you are not going to have sufficient time to prepare the report, then I would expect an application to be made to the court on evidence explaining why and so on, for an extension of time. Similarly, after receiving, if you form such a view after receiving the claimant's report on the or before the 20th of September, if you, in consultation with your experts, form the view that it's not going to be possible with all proper conscientiousness and diligence to complete the report by the 25th of October, then I would expect an application to the court on evidence explaining the hows and whys for an extension of time. What I wish to avoid, and which would make me extremely grumpy, is if after the times specified for these things to happen, if the court is then asked to deal with the position. All right.
Sure.
Now, I wish to add in a further paragraph, which would come between 8 and 9. Whilst I'm doing these things, Ms. Burt, can I ask you, when we're concluded today, for you to prepare a further minute of the orders that I've indicated should be made? So after,
Yes, absolutely.
thank you. After paragraph 8, there should be a further paragraph that you can redraft it if you think it would be better expressed, but by the 20th of December, the experts, and there would be, in this case, 2 conclaves. There would be a conclave of the forensic information technology experts and a separate conclave or conference between the quantum experts. So the experts should meet in conference on their own and discuss their reports and produce a joint report setting out the matters on which they agree, the matters on which they disagree, and in relation to the matters on which they disagree, a succinct description of their position on each of those points. Is that sufficiently clear?
Sure.
Yes.
Thank you. All right. So what does that take us to now?
If it's acceptable, I had 2 points on the undertaking that may be useful to finalize at this stage. We were at page 236 of the bundle. There's one point that hasn't been addressed yet relating to what is item 4 at the top, where the previous draft, which Your Honour endorses as prepared by the defendant, was where the counsel reasonably believed that any part of the relevant forensic images are relevant and material to the proceedings. One of the reasons why we added the provision at item B relating to avoiding commercially sensitive, private, personal, causing harm is because, of course, relevant and material under the typical provisions for disclosure is not the sole determinant in terms of providing documents. If it is relevant and material, we are still able to typically either redact, as you had previously suggested, or withhold from disclosure documents that are commercially sensitive, private, personal, confidential. So in our view, if we do retain the language that was put forward by the defendant, then at the very least, we need to include that clarification here as well. It is not just relevant material, but also not commercially sensitive, private, personal, confidential.
Well, the difficulty I have with that, Ms. Burt, if there is information which is commercially sensitive, private, and so on, it may nevertheless be necessary to disclose it to somebody on behalf of the defendants to obtain instructions. I don't. Now, of course, ordinarily, where an objection or a claim for confidentiality is made, that will be made in relation to particular documents, and the court will assess the significance of them and the necessity and so on, and make a decision. In this case, I do not see that it's appropriate to have a blank exclusion in relation to any material which is commercially sensitive, private, and so on. It might be necessary, and it might be in the interests of justice, that material be disclosed to the defendant in order to take instructions, notwithstanding the material is commercially sensitive, private, and so on.
And that's exactly why we had incorporated B, which says you take reasonable care not to, but if you do, then you provide us with the exhibits, the potential exhibits after you filed, because that creates protection, because the original draft does not have any protection.
Yeah, the difficulty I have with that is essentially the one that Mr. Doherty has put forward. And perhaps I come from a background where I think the law of professional privilege is a little different in some Australian states than it is in the United Kingdom, for example. One view that is taken in most Australian states is that where copy documents, where copies are made of documents which are not themselves the subject of privilege, the provision of copies of those documents to counsel may be privileged because it discloses the brief and the reasoning process of the party putting them forward. That analogy seems to me to apply here, as it may well be that to disclose the particular documents which are provided to the client discloses something of the instructions being sought by the solicitors from the client and something of their reasoning and the way they're approaching the case. So I'm not attracted to that provision. If you want, you could try and work out some more complicated regime which involved, well, I'm not sure how it actually, I can't think of one that would enable the issue to be, as it were, litigated by satellite litigation before it comes up. It seems to me in the first instance, the solicitors, as I said, the wording in what was paragraph 4 should be tightened up. It's not sufficient that the material should be relevant and material. It should also be that it is necessary for the material to be disclosed to the defendant in order to take instructions. But if that is necessary, then they should be disclosed, is my view. And that it is not proper to provide a list of those matters because it discloses the matters on which the solicitors have taken instructions, which is, in my view, a breach of privilege in this case. So I would see that it be sufficient for the undertaking to be confined to the case that it may be given to the defendant. I'll come back to what's meant by the defendant. Be given to the defendant where the defendant's solicitors reasonably believe that the relevant material is relevant material and necessary for the proper pursuit of the case. As to who it should go to in the first instance, I would think that you should discuss who it might go to. I would have thought probably in the first instance the appropriate person on the defendant would be, if they have one, their IT manager or expert. I don't know whether the defendant has such a person, but you might discuss that.
Yes.
That would probably be appropriate in the first instance because such a person would not ordinarily be involved in the sales and commercial aspects of the business.
Yes.
And it'd be confined to such a person. And that person would have similarly, I'm not sure how this scheme works, but that person would similarly have to have given an undertaking that they will not disclose it to anybody else within the defendant. And that, as I've said, if the defendant solicitors believe that it's not sufficient to take instructions from that person, then they would confer with you about adding other persons who should be added to the list, and if agreement can't be reached, then you come back to the court. So
thank you, Your Honour.
Right.
Thank you. And just very briefly to conclude on the undertaking, I think you've already just now addressed us again on the issue of providing it to third parties. Mr. Doherty did not make any comments relating to paragraph 7 of the undertaking, which is on the next page at 237. But that was another paragraph where there was some contention between the parties because what we had requested, and I think you said earlier, only a confirmation from those third parties that they would not disclose it to the defendant. Yeah. as you've said now, I think what needs to be added here is exactly as you say, that of course that the individual and the defendant then also does not disclose it to others. But I take it that Mr. Doherty agrees, and now having heard your Honour's helpful comments.
Is there a problem with paragraph 7?
So I think the issue historically was it's provided it's not approached in terms of the solicitors providing an undertaking as to the conduct of third parties. I think if it's limited to them seeking confirmation, that's less objectionable, of course.
Well, paragraph 7, is paragraph 7 okay?
Yes, I think probably we'll need to interact with what the finalised wording of the remainder of the undertaking means. Of course, that's what they're signing up to. But provided that what it means is we will get confirmation from the IT expert and counsel that they're not going to disclose the documents without asking us to the defendant, then that's obviously fine.
Okay. All right. Let's move on.
Thank you. Yes, thank you, Your Honour. The final few issues should hopefully be brief. There's the next issue was the issue of the trial bundles. We had not addressed this in the note because I do think that this is an issue we can finalize with the different solicitors. We had purely provided some float there, mostly to the benefit of the defendant, because the dates again fell during the holiday period, and because we were conscious that we wanted to conclude the substantive parts before the Christmas period. So that was all, but we can certainly remove the extra time from the bundle days.
All right. Mr. Doherty, just before we move on, Mr. Doherty, do you want to address anything about that, or you can sort that out?
I think we just sorted out. I think now that we know that what the dates are for substantive steps, then that can all be ironed out.
All right, back to you, Mrs. Bird.
Thank you. The next issue, the skeleton arguments. Again, I don't think there is serious contention here.
Well, there is on my part.
Yes, yeah, and that's what I wanted to say. I mean, from our perspective, we are in your hands. We understand that Mr. Doherty may have comments.
Okay, well, there are 2 points that I wish. First, I prefer the skeletons be sequential, not an exchange. I prefer that the claimant put on their skeleton and then the defendant put it on subsequently, so that one can lessen the prospects of the, as it were, the famous ships passing in the night, so that the defendant will engage with the points made by the claimant. So far as, and by that time, of course, we're talking here 1 or 2 weeks before the trial, the evidence has all been disclosed, the documents have all been disclosed. Everybody's putting their cards on the table at this stage. There's nothing being hidden or kept in reserve. The second point is as to when. Now, the trial is to begin on the 24th, Monday, the 24th of February. I want to receive the last of the skeletons no later than Friday the 14th. That is so that I have the weekend and the week commencing the 17th of February in which to have the skeletons available to me. So I would want the defendant's skeleton no later than the 14th of February, and it may be perhaps the claimant's a week earlier, Friday the 7th. Unless, of course, you want to arrive at earlier dates, but I'd be surprised at that.
From our perspective, I think I'd suggested in my note, because I recalled Your Honour saying during the middle application that you had a preference, and that was why we'd included it. So yes. No objection either way, but it's what's best for you, really.
Yes. Yes, thank you. All right. What else? Ms. Burt?
Then thank you, Anna. That is also obviously agreeable to us. The next point was trial duration. Again,
Yes.
we are in your hands. The original dates were 6 days plus 2, and we noted that the registry provided slightly extended dates. So we thought that this may be an issue worth discussing.
Yes. The registry did not consult me about the number of days, but I thought either the registry or the parties had very sensibly realised that 6 days wasn't enough, and had sensibly set down 10 days. I say that on these, against this background. First of all, my gut feeling is that this is a 2-week case. It's not a 6-day case. It's not going to be done in 6 days. And that's reinforced by the committal hearing, which, if you recall, took 4 days, and some of those days were long days. And that alone leads me to believe that this case is going to take longer. So 10 days. Now I think one of you suggested 8 days with 2 days in reserve. Perhaps, Ms. Burt, you might be able to explain to me, does it make a difference in the fees that you pay, or what's the point about whether it's 8 days with 2 in reserve or whether it's 10 days? Is there any point about that?
I'm not aware of the fee implications
No.
between those two options. Our expectation at this stage was as well that the hearing may be an 8-day hearing, and that 2 days in reserve, therefore, would be as such in reserve to give the parties and, of course, Your Honour, some certainty relating to the dates while before we finalise the hearing, the trial timetable. But of course, if Your Honour prefers to simply confirm a 10-day hearing, and we can operate on that basis. And if some of the days are shorter, then that may be also helpful.
I'd be delighted if we can complete it in that time with some shorter days. But and I've probably expressed to you before, what I would particularly dislike is we don't complete it within the time set aside, and hence I do want it to be listed for the 10 days. Now, as I say, I don't know if there's any consequence to listing it for 8 with 2 in reserve or listing it for 10. For simplicity's sake, I would just list it for 10, but if you subsequently tell me it makes some difference how that's done, then you can tell me. But I certainly want 10 days to be available. Do you want to comment on that?
Just to jump in, I think that the only real material difference is the parties' approach to the trial timetable, because obviously if we've got 8 and 2 in reserve, then we'll try and schedule for 8. It just might be tighter. Whereas if we know that we've got 10, then we'll leave the appropriate amount of time rather than trying to hammer everything in. So I think it's really a question of ambition.
Yeah, well, in that case, I take your point, Mr. Doty, and I'd prefer you listed as 10, because once again, I think we've probably all got the experience that if you shoehorn it into 8, you end up taking what's really a 10-day case and timetabling as if it was an 8-day case, and then we end up sitting long hours, or witnesses come at times that are inconvenient and so on. So we'll make it 10 days so you can work your timetable on that. There is one further point, though, that then arises, and that's the expert evidence. It is generally my preference that the evidence be taken concurrently. What we in Australia refer to as hot tubbing. I'm not sure if you refer to that in England, Mr. Doherty, but I prefer that the evidence be taken concurrently, not separately. Where are the? I assume you've appointed your experts, have you, or have you not? Are they going to go to Dubai, or are they going to be elsewhere, or what's the position?
On the claimant side, our experts are both in Dubai and in London, which is unhelpful. So there's no final determination whether the relevant individuals will be in Dubai. I understand the hearing is now in person, as such it may well be that they will now all be in Dubai, but this is not yet finalized. And could I clarify your Honor's suggestion? So there would be no cross-examination and you would immediately go to hot tubbing rather than having both cross-examination and hot tubbing?
This is the process that I ordinarily will adopt with experts. They are both sworn in, one after the other. Then each counsel in turn, so let's follow the usual process, the claimant will then introduce into evidence the claimant's expert's report, which will in effect be their evidence in chief, but they put in their expert report. Then the defendant will similarly lead the evidence from the defendant's expert by producing the defendant's report or reports. I will then address questions to the experts as I see fit. Ordinarily, the approach that I take will depend upon what's in the joint report. So, for example, where the experts have agreed on points, I may ask for some clarification on them, or I might go directly to the points which are an issue and ask each of them to explain their position. In doing that, I will invite the experts that if they disagree with anything said by the other expert or wishes to qualify, elaborate upon, and so on, then they should do so in the course of that process. When that is finished, when I have finished addressing questions to the experts and inviting them to comment upon what each of them has to say, I will then invite each counsel to address questions to the opposing counsel in the opposing expert in the nature of cross-examination, and finally something in the nature of re-examination. The process will be somewhat flexible. It'll depend upon what happens in the process when I am questioning them. And I expect and rely upon counsel to be sensible in their questioning of witnesses so that they don't seek to have witnesses go back on things which they've clearly expressed opinions on, unless there is some proper basis for it, such as a misunderstanding of the facts or so on. But that basically, if that assists Ms. Burt, that's basically the approach that I usually take in concurrent evidence. Now,
thank you. That does assist.
It comes back to the question of where the witnesses are. It's more convenient if they're both in the courtroom, if both or all of them are in the courtroom, but experts are one group of witnesses which, if it's more convenient and economic for them to give evidence by video link, then so be it. Albeit taking into account time differences. So we're in February, the time difference is 4 hours to London, is it?
Yes, correct for us.
Yeah, well, you'd bear that in mind in working out a timetable. If you want any witness to give evidence by video link, and if you do, then I think you probably have to make an application, do you? I'm not sure. I can't remember under the rules whether you have to seek permission to do that or if we simply inform the court. Perhaps you could look that up. If you need to seek permission, do that. If not, then inform the court what you propose to do. Mr. Doherty, where are your witnesses, your experts?
We've been going on was that they would be present in Dubai for trial if it's an in-person trial.
Yeah, good. Well, that's preferable if that can be done. Yeah. What about are there any other witnesses who, for one reason or other, can't go to Dubai?
Not on our side. In fact, witnesses will certainly be in Dubai, and we are taking all your comments on board. I'll confer, but I assume, again, this should be uncontroversial, and we can also obviously discuss between the parties closer to the time as well with respect to these issues.
Yes. Well, we've said that there's to be a pre-trial review on the 10th of January. That would be the time to deal with these things. Obviously, you'd have conferred about it before that, and then we'll deal with those things on the 10th of January.
Yes, absolutely.
All right. Anything else?
There was one final issue that was raised by Ms. Doherty in the note yesterday relating to privacy.
Oh, yes.
This is also an issue that we thought it was still in discussion between the parties, and to some extent it seemed to us that it was better placed for the pre-trial review in the hope that there's some finalization on it until then, or otherwise it could be raised then, because primarily, of course, the issue of privacy relates to hearings. Yes. And the next hearing is, the next merits hearing is the final hearing, at least at this stage.
Well, Ms. Burt, I had understood, perhaps I misunderstood, the privacy ruling applied only to the committal hearing. Doesn't extend through to the trial.
So we were in discussions with opposing counsel on this issue because, as Your Honour will recall, the reason that was given, and it was by a former employees' counsel in the committal hearing, as Your Honour recalls, with respect to privacy, was that there's a concern about third-party information, client information. This was the transcript, day 1, page 10. And Mr. Doherty then says, I don't have any objection to what my learned friend has said. I don't have anything to add. It's a perfectly sensible submission. And we also agreed to that. And to some extent, this was a perfectly sensible submission because, of course, under the IDC, if a document is referred to during a hearing, it is then not covered by 28.64 of the IDC. 28.64 says documents should only be used for the purposes of the proceedings. But of course, if they're referred to, then that allows them to become publicly available. And we are referring to, in the committal proceedings, as much the same documents will be, of course, before the judge in the final proceedings. These are client documents. So the same point that was raised in our view applies with respect to the upcoming hearings.
Right. Well, I take a somewhat different approach. So far as the trial is concerned, my starting point is that it should be in public. Insofar as there is any commercially sensitive, confidential material which one party or the other wishes to not be public and be confidential, then you will need to identify that and seek an order in relation to the particular documents or in relation to evidence, primarily cross-examination in relation to that evidence or documents. But my starting point is that it should be public, and only if there is good reason should there be parts which remain confidential. And the risk of repeating myself, they should be identified. I'm not inclined to put a blanket of confidentiality or privacy over a matter, but rather to work the other way, that it is open to the public, except and if and when particular documents are identified and an order is made in relation to particular documents or in relation to particular examinations.
Yeah, thank you for the direction. We can take that away and discuss with counsel on the other side. I am quite confident that inevitably there's going to be a list of personal financial information, which will be addressed. So we will need to come up with some sort of practical decision, because I imagine it may not be all that practical if every, so often the proceedings suddenly,
Yes.
the room is closed, or I mean, we are in an in-person hearing here, so obviously the room is open in a public hearing. So there's going to be some flexibility.
Yes, and I don't prejudge the matter, of course, but similarly, the parties should not assume that because one party considers it confidential and commercially sensitive, or even that both parties think it's commercially sensitive, that the court will necessarily accept that and make some sort of private hearing order in relation to those matters. The court will need to be persuaded that it's in the public interest that the particular documents or particular evidence not be disclosed in the usual way.
Thank you, Anna.
If possible, just to make a couple of points on that from the defendant's perspective. You're quite right. This court has been repeatedly clear on proceedings requiring exceptional circumstances to depart from the principle of open justice. That's NNC. I think more recently in the KPMG and DFSA matter, as well as another case I've been involved in, which is very similar to this, involving high net worth client information in Lee International for Justice Sir Jeremy Cook, where he refused a privacy application because, frankly, it's the nature of the beast. If you're going to go to court and vent commercial issues, you can expect commercially sensitive information to be placed before the court. So that's obviously these proceedings. I think we did leave an open question, which we haven't necessarily closed off when it came to the committal application. So I've gone back to the transcript, as my learned friends did, with the former employees' application. I think what was said is, of course, it only applied to contempt, because I think the basis was Rule 52.28.
Yes.
What was cited was Latif and Layla, Justice Martin's order for the hearing to proceed in private, but a judgment given in public. And I think what had been suggested by the former employees' counsel at the outset was there be an order that for the time being we sit in private, so that one could take a view when we got to the end of the hearing whether or not there was in fact anything that needed to remain in private. I think our position is we've had those hearings, and Your Honour, of course, has delivered judgment. Nothing has been identified, or there was nothing certainly that struck me of being of particular sensitivity that came up during the court's middle hearing. And certainly there was nothing in Your Honour's judgment that raised a compelling reason to depart from the normal principles of open justice. And so what our position was is, in confirming that we've now had the hearing, we took a precautionary step at the outset, but those proceedings might probably now simply be made public, because there is no particular commercially sensitive material that was discussed, which was rendered in the judgment.
Mr. Perhaps I might, well, not perhaps, I will ask you to do this. Would you please correspond with the, I was going to say with the claimant, well, their counsel is sitting here, and in particularly with the former employees, and put to them what you've just said to me, and if the parties are all agreed, perhaps if you can then inform the court that that is the view, that there's no reason why the essentially the transcript should remain private, or if there is a difference of opinions, express that difference of opinion, and I'll deal with that if and when that occurs.
Yes, I'm grateful, Your Honour.
All right, are we done?
Yeah, well, it depends whether Your Honour wishes me to address you briefly on an update on documents, because I think I need to come back to you on that.
Oh, yes,
on
please.
production.
Yes. Yes.
Sorry, let me just check my note and make sure that there's nothing else in terms of timetabling to get out of the way. But I think we've covered off the issues which I had flagged this morning. And Your Honour will have seen my note. Really, to summarise the position, and I'm not sure that there's a huge amount to add to that. In effect, the defendant instructed an external IT provider to run the searches following the last series of hearings we had on production of documents and Your Honour's order. And that returned about 90 gigabytes of data. And what happened is the defendant's representatives then commenced their review. Whilst that was ongoing, what became apparent in a number of instances was that there was a problem with date ranges of things being returned, or documents that had expected to be returned within particular date ranges not being there. So that was investigated. It turned out to be the case that there was some issue, it appeared, with the searches not returning things that were expected. And to avoid simply repeating the same problem by going back to that IT provider, what the defendant did was instruct a new IT provider who has experience of dealing with this sort of litigation to run it again. So it's a new provider called Lemiere. They've carried out a process by which they have extracted across a number of different devices and systems data which has been placed onto a review platform, Relativity. And then once that material has been extracted, it's then fitted with the various different parameters. So it's date ranges, and then, of course, the series of search terms that came up. So I think it was what was something like 2 million documents becomes 40,000 becomes, I think it was 18,000, which went into the review batch for manual review. That's now underway because, in effect, the process had to restart with the searches. We've sought to make up ground. So I think at the moment, or in my current times, we have my learned junior as well as the associates who have already been involved in the case. On top of that, another 6 associates assisting with the review, as well as a team of what was 5 and I think is now 6 junior counsel who've been brought in to assist with speeding up the review process. The issue which we had when it came to providing concrete estimates of timing was actually just partly down to a data set of knowing how many documents were being reviewed per day. Because, of course, if you're at day 0, you don't know. If you're at day 1, you've got a small sample size to see how many you're getting through in a day. And by day 3 or 4, it becomes clear. So I think at the moment, the state of play is about 8 of 18,000 have been reviewed. We think that comfortably, we've given the estimate of the 12th of July as a somewhat of a long stop because the progress actually seems to be quicker than that. But we didn't want to be overly optimistic. But I suppose the short point is an issue was identified. We actually think that the court and the claimant can take comfort in the fact that where an issue was identified, it wasn't simply glossed over, but in fact, we've gone to lengths to ensure that we're getting it right because although we actually share the frustrations when it comes to the timing, what's ultimately important and what the defendant absolutely did need to do was to make sure that it's complying with its duties of disclosure to the court. And that's what we're doing. It's unfortunate. Trial is still some way away. We think that the minor delays aren't going to, well, we've already discussed the timetable, but the minor delays are not going to risk trial dates or anything like that. And the reason that when the issue was identified, we didn't put in an application for an extension was simply we didn't know until the review was underway how long it was going to take because we didn't know how many documents a day we were going to be able to churn through. And that's become more recently apparent. And then the final update on the former employees.
Yes.
They were written to, I think it was at the beginning of June, that there has been exchanges of correspondence in respect of their documents. Our understanding is that we're going to be getting materials from their solicitors today, hopefully. We had hoped for yesterday so that we could come into the hearing with it, but today is our current understanding. So that process is underway. Of course, once those materials are received, they'll need to be, we don't know how much it is, but it will need to be reviewed and checked for responsiveness and so on. But again, one doesn't expect it to be a future unwieldy exercise, we'll be able to update, I imagine, the claimant once the data set has been received. But that's where we're up to. The process should be completed in relatively short order. We, of course, apologise to the court for the inconvenience of it being later than we had hoped, but I hope that Your Honour would understand it's not either from the defendant's want of trying or effort.
Yes, one difficulty or issue which had occurred to me, which I hope now will not arise, is this, that if the former employees declined to provide or failed to provide to the defendant the material that was requested and the material that is sought by the claimant, that might cause further applications. And of course, that's the sort of thing which has the potential to cause delays and knock-on effects. So that obviously the sooner the better that be done. If it's it sounds like from what you said, it's you would expect it in the next day or two. I do ask that if you understand that the response is not fulsome, if I can use that description, that you inform the claimant as soon as possible, so as to again attempt to get these things dealt with. What I don't want, of course, is for them to find out for the first time on the 12th of July, and then to have further correspondence, and we go into August, and then we get some application which is going to then have the possibility to derail the whole matter. So, as always, the more you can inform the claimant about what's going on, the better. All right. Anything else?
Just coming on. Okay.
I was just going to address
Mr. Doherty first. Anything else?
Apologies.
I was just going to address, if you need me to, the payment into court. I'm not sure it is a seriously sustained application. I'm not sure that Ms. Burt knew what she was actually asking for, but I've given you the background.
Well, I'll go back to Ms. Burt and ask her what she is asking for.
Thank you, Your Honour. And that is exactly the point I wanted to address. It is a certainly serious point, especially in light of what we've just heard. So we've heard obviously the same excuse relating to the IT provider I've already addressed, but now we've also heard that the former employees, what is it, a week after the deadline for providing their documents today, why are they not complying with the deadline that was imposed by the court? There's no explanation that has even been attempted to be provided. And also what we've just heard is that the defendant may or may not be able to provide the former employees' documents by the 12th. So there is not even an estimate with respect to that document set at all. We do find that wholly inappropriate. I really don't know what else to say. So we do think the sanction is the only way to create any kind of adherence to the timelines. And what I had referred, Your Honour, to was paragraph 4.3 of the RDC, where I said when the court makes an order, it may make it subject to conditions. And if you follow on to paragraph 4.6 of the RDC, it says where a party pays money into court following an order under rules 4.3 or 4.4, which are the ones we referred to in our note yesterday, the money shall be security for any sum payable by that party to any other party in the proceedings. So we believe that that is a sensible order that should be granted as part of the new CMC order, the new procedural timetable, whereby a sum of money is paid as security and held by the court until the defendant owes that sum of money to the claimant in any future order, and then money is then released as such. That is what the RDC provides. Yeah.
All right. All right, thank you. Mr. Doherty, one matter relating to specifically to the former employees. As I understand what you have said to me today, so far as your instructors have not yet received from the former employees the material which they say they're going to provide, and therefore you're unable to say when you will have completed a review of the material and therefore be able to produce them. If, and I don't intend to be meeting trouble halfway, but if there is a problem in relation to the material from the former employees, then the proper course is for the defendant to make production of all of the other documents and inform the claimant of the documents it's not able to produce, when it expects to be able to produce them, and confer about that. If agreement is not reached about any extension of time or any other matter, then you should make an application to the court.
And yes, you're quite right. We don't have the documents in hand yet.
No.
And as I suppose to respond very briefly to the points that were made, as we had understood the court's order following the disclosure hearing, the documents are in the defendant's control. That requires them to at least request the production of those documents from the former employees. Of course, the court's order for production doesn't directly bind the former employees in that sense, but we've made the request pursuant to the order. We can only deal with what's in hand when it's in hand, which is why we'll update the claimant once the documents are in hand and we know what we're dealing with.
Yes.
And then again, if I need to circle back to the idea about payment into court, and the reason I said it's not a serious application is the first time it was raised or flagged was yesterday. The first time it seems to have been thought about properly was today, but there's no attempt to engage in what the law requires. But for example, if one was to look at the English White Book on this, what you have to show is some deliberate flouting of court rules or bad faith. And I've given Your Honour that it's Ali versus Hudson's the case there, but
Yes.
I've given Your Honour the circumstances, and I don't know if I need to address it at any more length.
No, and this is the decision I make in relation to those matters. Ms. Burt is going to draw up a minute to further orders. That will include an order that the defendant comply with the, I've forgotten the date of the document production order, May something or other, by the 12th of July. I will not at this time make any order that the defendant pay any money into court, or that the defendant, or that there should be any sanctions on the defendant. However, I do wish to make it plain that if for any reason the defendant is not able or does not comply with the order by the 12th of July, the proper course is to confer with the claimant prior to the 12th of July, to seek to make some agreement about that, and if there is not agreement, to make an application to the court. And if that course was not followed, then the court would have reason to consider whether or not the defendant is complying properly with court orders. All right, Ms. Burt,
Thank you, Your Honour.
I'll await your minute to be delivered to the court.
Thank you, Your Honour.
Is there anything else?
Not from my side, thank you.
All right, well,
Thanks to Your Honour. Thank you.
Thank you both for your assistance. That concludes today's hearing. Thank you.